for our Zoom meeting. We are scheduled from 1 to 3, but the chair, Krista Obel-Eshelman, Sandy and Debbie and Talitha and I met yesterday, and we've gone over our agenda, and we don't plan to keep you that long. We value your time. We want to just move as efficiently as we can because we know we're going to be tapping into you as resources for some pretty involved drafting and reviewing work later on. So today's goals are on the agenda, but what we're hoping to do by the end of this session is to kind of identify our particular tasks and then create the opportunity for people to volunteer for kind of subgroup work. But we'll begin. Sandy, do you want to do the roll? And just our goal today here is have folks introduce, well, Sandy's going to call roll and also identify the organization or your affiliation with the Justice or Municipal Courts.
Great. So yeah, I'm just going to call the folks who are here. I'm going to go in alphabetical order. So I'll do the chairs first, then we'll go in alphabetical order for who's here. So Justice Duncan? Here. And then do you want the, just to be clarified, do you want the folks to identify their own affiliation?
Sure, I will. Okay. So I'm Rebecca Duncan. I'm on the Supreme Court. Prior to that, I worked as a public defender doing appeals, and then before that, trial work. Did not practice in the Justice or Municipal Courts, and so this is a newer area for me. Great.
Krista?
Hi, Krista Obel-Eshelman, and one of the co-chairs here from the Oregon Law Commission. I practice appellate law in the juvenile law area. I work for Youth Rights and Justice.
Great. Let's see, I'm trying to see who's here would be next. It looks like Brian is not here, Anna is not here. So it looks like Dan Cross is next.
Yes, I'm Dan Cross. I'm the judge of the Washington County Justice Court, where I've been on the bench about 3.5 years now.
Great. Thank you again for being here.
My pleasure.
All right. Next, I think we have Greg Gill. Greg, I think you're up. I think you're on mute. Yep.
The mute on all these platforms is a different spot, so I'm clicking on it, talking away, divulging all my secrets, and then I was on mute. Greg Gill, Eugene Municipal Court, presiding judge. Thanks.
Thank you. Next, I have John Henry Hinkson. John, you're on mute. John, can you hear me? You're actually on mute. Oh, there you go.
John Henry Hinkson from Oregon City, private criminal defense lawyer appearing in circuit, justice, municipal courts.
Thank you, John. Jordan.
Jordan Hooper with the Lane County Public Defender's Office. Before that, I had a private practice where I practiced a lot of criminal defense in municipal and justice courts.
Great. Next is Monty Ludington.
Good afternoon. I'm the presiding municipal judge for Pendleton, Oregon, as well as a attorney in private practice in civil matters.
Thank you again for being here. Kimberly.
Yeah, this is Kimberly McCullough. I am the legislative director for the Office of Public Defense Services, and we, provide basically oversee and provide funding for all of the public defense contractors across the state, and I'm glad to be here. Thanks.
Thank you. Jim Nass. Jim, you're on mute.
Jim Nass, retired Court of Appeals Appellate Commissioner.
And Jim, before we go out, thank you so much for your work on the memo. We'll talk about that a little bit later.
Thank you.
Next, Channa.
All right, found the unmute button. I've had similar problems as other folks. Channa Newell, I work for the Judiciary Committees in the Oregon Legislature. Happy to keep tabs on this committee and its work.
Great. Thank you, Channa. Always appreciate it. Next is Paul Smith.
Hi, I'm Paul Smith with the Appellate Division at the Oregon Department of Justice.
Thank you so much. Heidi.
Heidi Van Kirk. I am a public defender in municipal and justice courts in Umatilla and Morrow counties.
Thank you. Thank you. I realized, Victor, I missed you on the alphabetical. It's because I had you listed originally with Jessica, but Victor, you're up.
Great, no worries, Sandy. Victor Ruther, staff attorney with the Office of Legislative Counsel.
Thank you very much. And then finally on the members of the committee, Natasha.
Hi, Natasha Zimmerman, Deputy City Attorney with the City of Salem. I was a prosecutor with the Salem Municipal Court for a number of years, and now I oversee our 2 prosecutors. We're not a court of record.
Thank you. I incidentally overlooked Amy, but not intentionally.
Hi, Amy Zubko, Oregon State Bar Affairs Department.
Great. And I know 3 other people are here. I want to introduce Carrie. I know you are clerking for the summer. I'll let you introduce yourself again.
Hello, everyone. My name is Carrie Flieger. I'm currently clerking with OPDS under Kim. I'm very grateful and happy to be here, and hopefully I will be learning a lot. So thank you so much.
Thank you. And then the Oregon Law Commission folks, first want to introduce Debbie Thurman, who is our administrative coordinator. Debbie, you're welcome to say hi.
I'm Debbie Thurman. I'm the administrative coordinator.
Great. And then last but not least, our Oregon Law Commission fellow and who's been doing work for this group already, Talitha Randall. Okay. Thank you all for being here, and I have everyone recorded.
Great, thanks, Sandy. The next item on our agenda is an update on work group members. Last time we met, we identified different groups of folks, kind of categories of people we wanted to reach out to, and also some of you followed up with additional suggestions, and Sandy and Debbie have been working on reaching out to those folks and kind of figuring out who will be part of our group, both at a voting member level and as an interested party level, and that work is underway. Sandy, do you want to just report in on that?
Yeah, thank you all for providing names. I keep doing that, and I think it's going to be more clear what types of roles we're looking for when we talk about how we're going to distribute the work later in this meeting. I think that, and that will be discussed. I think it'll be more clear, but keep providing names. We have kind of the leadership of the group, along with myself and Talitha and Debbie with the OLC, along with the OLC chair, P.K. Wrinkles-Pearson, who was with us last time. We'll review those names and roles specifically as needed per the subgroups. And then when we form the subgroups, when we're talking about topics that are specific to the areas of appeal, whether it be municipal or justice, whether it be civil or criminal, it's very likely that we're going to need additional folks to at least join us for 1 or 2 meetings to help us understand specific areas. And that's in the terminology of the Oregon Law Commission. Those are called interested parties. And we're going to welcome and need folks to represent those groups moving forward. So no specific names to add to the group right now, but keep providing as we continue to learn who they are. Just let me know. Thank you.
Any questions or comments from anybody about group membership? Okay. So our next item is the discussion, just kind of to review the scope of our particular charge from the Oregon Law Commission. And then Krista and Jim may want to pipe in on this too, but we have both a large and narrow task. Our task is narrow in that we are just specifically charged with looking at appeals from justice and municipal courts. And so it's quite procedural. And as you've seen from the materials that were circulated for this meeting, it's quite involved and big that way, in that we are going to have to dig into a lot of different statutes and figure out how they interact currently and whether we want to propose any changes. So it's broad in that sense. I mean, that involves a lot. It's also narrow in that it's just the appeal process. So how things are going to go from our justice and municipal courts to the next level of review, and then possibly to another level of review after that. And so that's our focus. When we spoke last time, there's a lot of issues around justice and municipal courts that people were raising in questions. And I think those are things that the commission could look at beyond this group, but for our purposes right now, I think we'll be quite busy just trying to untangle the appellate process for these types of cases coming out of the justice and municipal courts. And so that's what our charge is. Jim Nass, and as you know from our last meeting, those of you who were with us for the last meeting know that this project is an outgrowth of a prior Oregon Law Commission project that Jim Nass and Paul Smith and perhaps others were involved with. And Jim, is there anything that you want to say about how this kind of spin-off came out of the last project and how it might relate? Because I know there was revisions of the criminal appeals projects, and it might be that in our work might reference some of the procedures that were created for just regular criminal appeals coming out of circuit courts.
Thank you, Chief Justice. The original link arose from ORS 138.057, which was directly within the scope of the former work group's scope of duties. 138.057 deals with appeals from municipal and justice courts of record. And it looked like there needed to be some changes made to that statute. But the more we looked at it, the more we realized that those appeals implicated appeals from courts not of record, and the criminal appeals work group determined that they did not have the expertise to address those larger issues, and so that's what led to the recommendation that the commission form a separate work group just to study appeals from municipal and justice courts.
Yeah. So, and that one statutory provision that you just mentioned, Jim, that has led us to kind of our initial work that Talitha and you have done. Hopefully everybody got with their attached materials Talitha's flow chart, and maybe Sandy, you can pull that up.
Yeah.
So this is just kind of a glance, gives us a quick glance at how complicated things can become quickly with these. And so Talitha, as Sandy mentioned, Talitha's with us as our law student fellow, and she has started to go through the statutes governing appeals from justice and municipal courts. And here is kind of a first take at the flow chart of the law as it currently exists. And I think the takeaway from this chart is if you start at the gray box and then go down, you will see that depending on how you answer all of these questions, you might be in starting from left and going right across the screen. You could be in ORS chapter 53, 157. You could be in chapter 221, chapter 19, chapter 138. So, and 153. So we have a scattered range of statutes that we're going to be dealing with. And so our first step is going to be reviewing those, seeing how they're interconnected, and then talking about how we might simplify them. So that's Talitha's work. I think that's just a great overview, and thank you, Talitha, for putting that together. And then of course, we also have Jim's overview, and Sandy, we won't review it together. It's going to be a tremendous asset. Thank you, Jim, for doing this. And so Jim's gone through those chapters and sorted things out by court type, and then within each court type, criminal, civil, and violations, and kind of tracked through all of the statutes and saying this is the process for these types of cases as someone would appeal, and then gone the further step of identifying potential issues that the group will consider. And some of them are just phrasing issues, others are policy issues, but that gives you a preview of the types of questions that are going to arise for our groups. And so that's our task, is to sort through all of this and make proposals and then present them to the Law Commission. And we will be working with our Legislative Council representatives for drafting purposes. But that gives you a sense of the level of detail that we're going to have to get down into. And so along with Sandy and Debbie and Talitha, and then Krista as the co-chair, we were thinking that our next step should be to, because we're going to be getting in that level of detail, break ourselves into a smaller subgroups to take on particular statute reviews and proposals. And so this is items 6 and 7 on our agenda today. And I'll talk a little bit about what we were thinking. We're not going to have anybody raise their hand and commit to a subgroup or take on a particular assignment right now, but what we want to tell you what we're thinking about, and then the next step will be for people to think about how they can be involved given everything else that's on their plates, in what capacity they want to serve. We are all really glad that all of you are here. We want to use you as resources, and we want to make this project fit your availability. And so what we're thinking at this point is that we'll be requesting today for people who are interested to get in contact with Sandy and volunteer for one of 2 subgroups, although we might have some people serving on both subgroups so that there's communication between them. And the subgroups, at this point, we're thinking we want people to look at the process for criminal appeals, and then a group will look at the process for civil appeals. And the civil appeal group will also take on the issue of how do you handle an appeal when the issue concerns the constitutionality of an ordinance. And that's the section of Jim's, the challenging the constitutionality of the charter or the ordinance. And so that will fall into, just for our organizational purposes, the civil sub-work group. And the idea is that those subgroups will meet perhaps on a monthly basis going forward, review the statutes, map them out, and then come up with suggestions about how they might be improved, looking at the things that Jim has identified. But also, I think that it would benefit this group if we kind of step back and we say, well, is there a clean slate way to approach this? What would be the easiest way for appeals to work from these types of courts? How much of the process can be the same from municipal and justice courts? How much has to be different? How much can be the same from violations to criminal cases to civil cases? Because as Jim's memo points out, we have, if you're trying to appeal this, you might be started one statute, be sent to another statute, and only then find out that you need to go to a third statute. So these are a little difficult even for lawyers to follow through to find the requirements for an appeal, and we want to make them as user-friendly, especially in light of the fact that many of the people who are going to be bringing the appeals are going to be acting pro se, and we want to give folks the tools that they need to be able to not kind of make a procedural misstep and jeopardize their appeals. And also, I think that will make things easier on the courts, the court administrators and attorneys, if it's all just a little bit more clear than it is now. So that's what we're thinking on with respect to subgroups. Krista, is there anything you want to say?
No, I think it's covered it. Thanks.
So any questions about that route going forward, or any thoughts? Jim?
Yes. When you say civil cases, are you referring to those pure civil actions that justice courts have the jurisdiction of, or are you referring to violation cases?
Well, both of those would go to the civil group, but I think in the end, violations might end up in their own lumped together. But some of the civil violations might be routed differently right now, right, than those criminal cases?
Yes, well, not necessarily routed differently, but I think the statutes in some instances are not clear whether the county has the right to appeal a justice court's disposition of a county violation.
Yes, so we would put the civil cases, yeah, and that would include civil violations.
Okay.
This is Sandy. I'm just curious with the group. I mean, we discussed this as a small group the other day, just trying to figure out the most efficient way to do it. I'm just making sure, is everyone comfortable with that plan? We wanted to make sure that this is a good chance for everyone to kind of, before we form those groups, this is going to determine the way we operate moving forward. I'll tell you from my role administering the Law Commission, where I've seen real success is when we're able to be as specific as possible in our in what we're supposed to be doing. And I think what a group with the once I saw the work that Talitha had done and Jim had done both, to see the complexity, the amount of statutes in front of us, this was going to be an impossible project for a group of 20 people to actually coalesce bouncing in statute and statute. And I think something that was really key is the idea that one benefit of the Law Commission is, especially working very closely with Legislative Counsel, and I appreciate Victor's here, is the idea that we're not constrained by the language that exists. We really can take concepts and work with our partner in Legislative Counsel and write new language and write new policy that can work for these areas. So we thought that these were two routes to go, and eventually we'd coalesce as a group to go through it. But that's part of the decision making we made to form, to move this direction, is that it would give a specific kind of direction task to either, rather than bouncing here and there. So that's kind of what we're thinking.
Just one question that I had, Sandy, and on the topic of the violations. Violations are kind of a weird existence in terms of the legally, because they are defined by Oregon statute as a criminal matter, but it's not really a criminal case, not subject to criminal penalties. So it's become something of a hybrid, I guess, if you will. So I'm not quite sure where it belongs in this context, or does it belong on the civil side or does it belong on the criminal side? There are certainly several issues with appeals from that, not the least of which is the cost involved for most of these defendants, pro se defendants, many of whom can't afford what the circuit court charges for the process. But anyway, I'll throw that out there. I don't have an exact answer for you, but it is currently defined as a criminal matter.
Justice Duncan?
Yeah, John?
I would like to advocate for not including violations in either the criminal column or the civil column. I think there should be a separate column for violations. I second what Judge Cross just said, and I would like to point out that with regard to violations, ORS 153.0301 says the procedures provided for in this chapter apply to violations described in 153.008, except as specifically provided in this chapter, the criminal procedure laws of this state applicable to crimes also apply to violations. So if you took a pure civil lawyer, they would be flummoxed by that command. And by the same token, a lot of criminal lawyers don't know much about violation procedure if they just handle felonies or misdemeanors. So with all due respect, I believe that there should be a sui generis. I have to use a little Latin since I'm from Texas. So I would advocate that we have a separate column for violations that's not in civil or criminal.
Okay. And for our purposes, it's just kind of where do we want the task of reviewing the current violation process to go, like with what group? And I'm not saying that we'll have only civil practitioners in a civil group or only criminal practitioners in the criminal group. It's just, we thought we wanted to divide up the work somehow and have kind of some basic categories. We had thought, well, should somebody look at how the justice process, only the justice process works, only the municipal process works? And we thought, well, We could do it that way, or we could do it kind of civil, criminal, other. But we were just kind of, for simplicity's sake, trying to divide a little bit of the reviewing. I do think that because we want to make this as simple as possible and the proposed statutory scheme as simple as possible, the two groups will come together and we will try and have a unified as much as possible approach to the appeals. So
may I respond to that?
Yeah.
On what you just said, I think you've made a good argument, maybe possibly without knowing it, to put a subgroup under criminal that includes violations. And that would fit perfectly, I think. Yeah, I think that'd be great.
We can do that. Anyway.
That's a good idea. That should work.
Okay. Other thoughts on how we structure the this review stage of our work?
Justice Duncan, I know there's some discussion in the chat, I don't know if anyone's watching, just about the idea of whether courts of record, or whether a court is a court of record or not a court of record, and how we deal with that. We discussed it briefly, and I know, Talitha, you looked at this a lot. Do we want to discuss that at all?
I am happy to have this group, I'm catching up on the chat right now, talk about that. I certainly, in looking at these statutes and Jim's materials, I mean, it's pretty quick. I mean, you quickly wonder, why aren't they all courts of record? Because then you would have a very straightforward process for the appeal. But yeah, so I see, it looks like Brian started the chat. If the group is okay, we can have that chat out loud as well. So Brian's question was, why do we even allow a court to be not a court of record? And Talitha, you were responding and saying it might be just they don't have technology. Any other thoughts on that? I'm just catching up.
Oh, that was just something that I read, I think.
Yeah, I see Judge Gill raising your hand.
Literally, thank you. I agree that technology is one aspect, but the collateral consequences of causing courts to have to become courts of record could be a lot bigger than what would be anticipated. And so I think it's definitely worth a discussion in potentially another subgroup, because obviously it affects what happens on an appeal. But it's more than just, hey, everybody should be a court of record, because the landscape shifts dramatically, especially in more populated areas.
Jim, can I ask, I'm sorry. Dan, go for it.
One of the reasons I think that at least for justice courts, why not all justice courts are courts of record, is you don't have to be a member of the bar or an attorney to be a justice of the peace. And so I think that may be part of the underlying rationale, that then there would be allow this process to go to a circuit court for it to be litigated in a setting where somebody presiding over it would have be a member of the bar, be an attorney, and so on. I don't know if that's the underlying rationale, because it must have been I've not researched that, but it strikes me as that's one potential reason. But there's also some weird things which twist in there too, because there's a statute about becoming a court of record, but you can't become a court of record if you're a justice court if you're within 50 driving miles of the circuit court for the county in which you're located. So it's one of those things where, like, we're one of the larger, if not the largest justice court volume-wise in the state, but I'm 12 miles from the circuit court, so would not be able to be a court of record, even though we certainly have the means and resources to set that up. Not all justice courts probably could say that, and lots of justice courts are not full-time everyday courts like my court is. A lot of them, are maybe cost prohibitive, because when you're doing court only, a day and a half, 2 days a week, it's a real cost benefit analysis.
Jim, can you give a little background? Was this issue discussed I know it was an appeals project, but when it was referred to another project, I'm curious if there were any thoughts about tackling that issue first, or was it just, was it more just focused on the appeals from a historical perspective?
No, there was no discussion of the details of how courts become courts of record, or why they would choose to become a court of record and why they would choose not to. My understanding is that one of the big impediments to becoming a court of record is that you then have to have either a court reporter or some sort of audio recording system that then saves all the audio recordings, at least for a certain period of time. And then there's also the question of if an appeal from justice court goes to circuit court. My understanding is that usually county council or the local DA handles it. If the appeal goes to the Court of Appeals, then the Attorney General's office handles it. So so if you made all justice courts and all municipal courts courts of record, at least for misdemeanors and violations perhaps too, you'd have a fairly significant shift in workload from local counsel to the Attorney General's office.
Thanks, Jim.
So something that we might want to put on our kind of side list of things to keep an eye out for is if, like Dan was saying, one of the obstacles to becoming a court of record is a statutory obstacle that you can't be within a certain number of miles of your circuit court, we may wonder whether or not that's something that needs to be in place. I don't know the history of the statute. I don't know the reason why that's there, but if that's an impediment to becoming a court of record, we might want to think about whether that's a necessary impediment at this time. And also, I wonder how much of a technological challenge it is to have recording and storing of records these days. But Brian's absolutely right that if more of these courts were courts of record, the appellate process for more cases would be simplified. And so I think those are things that we can keep on our kind of larger question list of things to continue to consider, and we should keep them in mind because there will be a need for us to do the review of the appeal statutes. But if more of these courts were courts of record, the applicability of the statutes we're reviewing is going to be more narrow. Other thoughts on how we structure ourselves? Sandy, did I see your hand?
Yeah, just really quick to follow up. One result of this group, if this is a question that lingers, and it feels like it will, because I think it is is that part of our work, if we go through the process, we present a more coherent and consistent appeals process. As a part of our report to the legislature is that an impediment to having a successful appeals process, or just in our research that we found a lot of issues coming from the lack of consistency in this area. If that's in our report that we can present to the legislature, that presents a solid foundation for a couple things. One, it could be an additional project, either continuing from this group or additional members for the Law Commission, or it's something the legislature may choose to pick up on their own. So I think our work here, based off the scope we've been given by the Law Commission, could lead to hopefully positive changes there, and it can be a part of our report, as the example that the Direct Criminal Appeals Project's report is how we led to this project. So that is the way that our law reform projects can work.
So what we want to ask of you as our work group members today is to kind of think about your interest level and if there's how you want to be a part of this group. We'll ask people to get in touch with Sandy and let Sandy know if you want to be a part of the reviewing groups on the statutes. And if you do, whether it would be what we're calling civil or criminal, which we've decided would include violations. You can volunteer for both of those if you'd like to. I think we'll ask some people like Jim to think about being on both of those work groups, given your history with their project. So if people can get back to Sandy and let him know if you're interested in serving in that reviewing capacity, and if so, which group or groups you'd like to do that with. We do, of course, hope to staff each of the subgroups with folks that have experience in justice courts, folks that have experience in municipal, so that the groups are as well-rounded as possible. And so we'll take the volunteers and kind of distribute people so that we have as many perspectives within each group as possible. And so Sandy, a timeline for, if folks can get back, let's see, today is Thursday, maybe by mid next week, by next week, Tuesday, let's just say next week, Tuesday, get back to Sandy, let him know if you're able to do this. Like I said, we really value whatever effort and time you can put into this project. The subgroups will be reporting back to the larger group to say, here's what we've reviewed, here's where we think there are problems with the current statutory scheme, and here's some ideas that we are proposing about how the scheme might be modified. Any sort of policy change would be brought to this group. And the policy changes, you know, you saw in Jim's memo, some of the things that we might have to decide, like certain types of judgments are appealable in certain categories, and then additional rulings in other ones. And so there might be policy decisions that we have to make. None of those would be made in any of the subgroups. So if you're not able to participate in a subgroup, don't worry, everything is going to come back to this larger group if it's a policy question. Any questions about going forward that way? Krista, anything? No? No? Okay.
This is Sandy. One thing to add about the subgroups is, and Victor, I know you're the representative from LC here today, but I know we have a couple. We'd like to have someone from LC available for both, just because that's where we want to do the bulk of the initial drafting at least. And we found that when we can have a representative from Legislative Council as a part of those drafting groups at the beginning, our process becomes infinitely more efficient because the language can be correct. We can get a draft which is actually written in the proper, in the acceptable language of the legislature as we meet along the way. And it's a really wonderful aspect of the commission, and thank you for that.
Just quickly, I'll be sure to communicate that to Jessica, and we'll do our best to make sure that happens.
Thank you.
And then the last agenda item we have before just next meetings is agenda item 8, which is about current court operations. And the reason this is on the agenda is because there's some of us who might not have direct experience with justice or municipal courts right now. And so I wanted to hear from folks who are operating those courts right now or appearing in those courts right now, who can give us, who might want to come and see them in person if possible, or come and watch by video. So if those of you who are administering those courts right now or appearing in front of them can let us know what's going on and what the options would be for kind of watching the proceedings and the time of COVID, that would be helpful. So we've got Judge Lettington. You guys up and running?
It's one of those I got to figure out if I hit the right mute button or not.
Yeah.
I'm still getting used to this. We're running on kind of a partial setup right now. Our city hall is still closed due to COVID. What we've done is we've still maintained video appearances from the jail for people that are arrested on arrest warrants or have been arrested on new charges. And then as to out of custody matters, we have created a alternate courtroom that doesn't require opening City Hall entirely for people to access. And we've been using that the last few weeks for appearances where people are out of custody that do want to appear and don't request a continuance. And when doing those, we just make sure we comply with social distancing, CDC recommendations regarding face masks, disinfecting. We've set the courtroom in a way to try to encourage that social distancing. And that's pretty much in a nutshell kind of how we're operating.
Okay. Judge Cross?
We we are up and running, kind of similar to the Washington County Circuit Court. I've adopted a general order which really mirrors the Justice Walters order with regard to the operations. So we're doing daily arraignments. Those were those were put in the category for those in those orders. We are offering, however, telephonic arraignments for folks that would rather do it telephonically, or do it via Team or Zoom. So we do have those types of things. We've done some hearings in civil small claims and matter, also through a remote appearance. We had our first traffic violation trial live in the courtroom yesterday, but I'm surrounded by plexiglass. As I tell folks, it's for your protection that I'm encased behind plexiglass. So we're muddling through. So far, folks have been pretty receptive to those things, and we're pretty liberal with setovers. We've been very liberal because some of our programs we use a lot in terms of our traffic violation diversion programs are not up and running, and so we're giving a lot more time to get things done, things of that nature. But we are functioning. We'll have our first small claim trial in person since we started doing matters live again tomorrow. We'll see how that goes. We don't have a mediator, so that's the one thing we're missing right now. But we have mediators set for the following week. Okay. So we're stumbling along.
Yeah. And Judge Gill?
I don't know where to start. So a few weeks ago, we finally opened back up when the governor and Lane County said that we could. And the entire time of trying to open up as many avenues to allow access to justice before and since then. So telephonic, virtual appearances allowed. We're having appearances in courtrooms within the restriction of how many people we can have in the courtroom. I've been planning about what happens when and if we go back to phase 1 and how our court's going to look like after that. And then trying to figure out how we're going to be able to fairly deal with the huge backlog of that we have in defendants that need to appear, and what happens with all the tangential issues that are attached to those. So we have a lot of misdemeanors that are filed in our court on a yearly basis, and so we're trying to make sure that those things are handled as fairly and as efficiently as possible. But we have definitely put our staff to the test in trying to make sure that these things are scheduled, and in a lot of instances rescheduled to make sure they happen. But everything is still available to the public. If we can't have someone in our courthouse or at the jail to be able to watch the sessions, that we've posted live stream on YouTube to be erased. I have a lot of concerns about that, but in some instances, it's all that we can do to make sure that the public still has access to all of our proceedings. So the idea is to try to get it so we can have access to our court without having to broadcast it that way. Hopefully that's coming pretty soon. We have yet to have a jury trial under these circumstances, although we do have one set coming up in August. And then other suppression hearings and other kinds of hearings that require a lot of witnesses, interpreters, other things that add bodies to our court becomes a daily challenge. But so far we've been able to accommodate everybody and every issue that we need to accommodate and move forward. And that's in collaboration with our city prosecutor's office, with our indigent defense folks, private attorneys around here, and then court staff and court administration. So everybody seems to be moving in the same direction and trying to get these things taken care of the right way. And so far, so good.
Wow. Really challenging times, but lots of creative and individual problem solving going on across the state. It's good work. So, and it sounds like if people did want to view any of these proceedings, you could just check your dockets and then appear in person, or however that proceeding is being made open to the public. So that's all available for any of us who want to see the process at the trial level.
And I'm happy to distribute. If there are links or schedules that I could help distribute, you could send those over, and I'm happy to get those out to the group if folks are just interested in seeing how that's working.
Justice Duncan, just to weigh in, I know one thing that we're trying to keep cognizant of is in our alternate courtroom, we have a limited amount of space. And so like people coming in to watch, we're really limited on that. I think our room's capacity is rated at 24 people. But when I'm taking into consideration the social distancing, might be even less. But in terms of somebody wanted to watch, we could probably make some other kind of arrangement, because I know with Zoom, it's a lot easier to make that accommodation.
Yeah. Yeah. Okay. Okay. So that gets us to our final item, which is just next steps, which if folks get in touch with Sandy about their interest in doing the reviewing work by next week, that would be great. And future meetings we'll schedule from there. I think the large group will, because many of us will be involved at the reviewing subgroups. Those are the groups that are going to meet for the next couple months. And so it may be a couple months before the larger group comes together to share its work. And we'll be sharing the work obviously in writing as we're trying to explain in a easy to digest way as possible how these statutes are working, how we are reviewing them. So we will, I would think the subgroups will be meeting within a month, and then after a couple months after that, we'll have this larger group come together. We don't have a fixed date for any of those scheduling, any of those meetings. It'll depend on people's availability. Sandy's good at sending out the surveys. And so once we get the groups formed, we'll send out the surveys, find out when you're available, and then we'll start meeting at those with the subgroups. And again, yeah, Sandy?
Yeah, just on the long-term timeline, I think it's something we briefly discussed, and it's good to kind of think about that. This is a project for our Law Commission calendar, we're really looking at for a 2023 session. The 21 session, there's no way. We have not had a great deal of success with the commission for short session. Our matters tend to be pretty complex policy, and they really do fit the longer sessions better. So the reality of our legislature, we're looking at 23, which means that we really want to be finished with our work, working with legislative counsel, especially somewhere in the September 2022 range. So I know that might feel a long way off, but with the amount of statutes that we need to work with, and those of you on this group who have been part of Oregon Law Commission groups in the past, these are in-depth discussions. We really do invite that kind of expert, detailed conversation that leads to statutes that will last, that will be better, that will actually improve the work for everyone who's here who works in this field every day. So know that we do have that timeline extended. So I don't want anyone to feel that we're rushed. We really just want to get this right. And we have a bill that's going to be well vetted and it's going to be ready to go. And when it does reach the legislature, it has a very high opportunity to pass.
I think the legislature will be quite busy in the next 2 sessions before we present anything for 2023. So that's all that I had. Krista, anything before we close? No. Okay. Well, great. That's everything that I had. Thank you all for your time. Sandy, anything before we close out?
No, just thank you all for your service, and we'll definitely, I appreciate it. I'm already starting to get some emails with people who, with their choices. We'll get back to you as soon as we can as we form those groups, and look forward to, I'll be at all the meetings, so I look forward to seeing you pretty soon. Thank you for your work with the Law Commission. If you have any questions, feel free to let me know.
All right. Thanks, everyone.
Great, thank you.
Thank you.